All right. Good afternoon, everyone. This is Curt Barone and Bill Maccarone.
Good
And
afternoon.
and we're here for another edition of Fire Law Roundup for October 28th of 2024. And I got uh my my media problem solved. It somehow gives me feedback if I don't hit this one button at just the right moment. It creates a lot of headaches for us. So, but Bill, thank you. Brad is tied up. He had some sort of an emergency hearing on a temporary restraining order that he just wasn't going to be able to get out of. And Bill was kind enough to fill in for him. And so
I'm pinch hitting. This is
you're pinch
perfect
hitting
since
it.
the
No
first
FLSA
case we're going to
cases
talk
this
about.
week.
It's Ty
Yeah,
Cobb.
well, no FLS. Yeah, Ty Cobb. Excuse me. No FLSA cases this week. So I really should
Yeah.
have you on when we're doing an FLSA case. But yeah, so let's. Did you have a chance to look at that first case?
Yeah, absolutely. The first case we're going to talk about comes out of Tennessee. It's actually Columbia, Tennessee, and it's a federal lawsuit that was filed last week by a fire chief whose name is Ty Cobb. I don't know if there's any relation there at
It's
some point,
Yeah,
but
John.
there's
Actually, where the Ty, I actually was looking at the case where it comes from is John Tyler Cobb. So
oh, okay. All right. So
middle
no
name. So
relation.
I have an
Well,
affection
who
for
knows?
people who go by their middle name. So anyway, it's a different
So,
story.
and the chief there found himself getting for this. The facts are basically the chief was let go, was fired, and he felt it was unjust the termination and that he was denied due process and a few things. So he filed a lawsuit, federal court, basically arguing that his right to due process was violated, First Amendment rights and whistleblower statute, Tennessee local statute that if you most likely, obviously, it's a Tennessee statute, but if you raise a potential criminal activity or bring criminal activity to attention of your superiors, you're typically covered from any discipline that might come as a result of that, and also retaliatory discharge. The facts boil down to apparently there was a report of a school shooting there back in May of 2023. Turned out to be a hoax, but at that particular time, the police chief, Mr. Cobb, I'm sorry, the fire chief, Chief Cobb, went to the high school to help out to see if there was a need for his assistance at that particular time. And at that point, he spotted a former employee of both the fire department and the police department who was on scene carrying a rifle, reported to be an AR-15 rifle.
Well,
And
it gets a little more complicated. Apparently, Cobb didn't see it, but
that's right. The
one
assistant
of his
chief did, or
deputies, and this
deputy.
can be a leadership problem because you're the
Yeah,
chief, and now one of your subordinates is raising, so you want to support your subordinates. And
absolutely.
so I kind of see like sometimes if you see it yourself, it's one thing, but one of your subordinates saying, "Hey chief, this happened. Hey chief, how we making out on that? Hey chief, did you ever get any resolution
Yeah,
on that?" And you like, well, I'm trying to do
yeah,
my job, and I want to show my
absolutely.
subordinates I'm doing my job, and
And in this instance, the chief was kicking it up the chain of command, more or less, to the city officials to say that, was this correct for him to be there at this time? And also, there were some reports that that individual, the former employee, was harassing some of the current employees of the fire department. So I think you're correct, and that makes sense. You get a lot of that, people saying, "Hey, what's going on with this? What's going on?" As that was occurring, eventually, a video correct? The video was found or uncovered somehow that showed this individual there at the scene with the rifle, or at
Mhm.
least showed him on the scene. I don't know if he had with the rifle, and that was brought to city manager, the city manager, and I believe it was the director of HR or another individual within city management there by the fire chief to say, look at this video. Eventually, criminal charges were filed, but the case was dismissed right before, or the case was charges were dropped right before it was set to go to trial. And at the end of the day, there also started to be kind of some accusations, at least according to the complaint, that the city manager's wife was making some accusations that the fire chief was acting strangely, that maybe he was having marital problems. It was really kind of off the wall. That it took a left turn as you were reading the complaint at that point, for sure.
Yeah, well, these are allegations, so we don't
Yeah,
know. Obviously, what we're doing is just saying what was in the lawsuit. We don't not saying what actually happened, but
yeah,
yeah, that the involvement of the city manager's spouse is really it's kind of concerning because you would think personnel matters would be confidential, and that would seem to suggest that the city manager is sharing information that probably shouldn't be shared,
Yeah.
or vice. I mean, we don't know whether it was coming from her and going to him or uh,
Yeah.
whatever, but there's always a concern. And this can happen with fire chiefs too. A fire chief's spouse, I've seen it in a couple of lawsuits where the fire chief's been accused of breaching confidentiality because the fire chief's spouse is making public statements about something. And,
Sure.
that just raises another
Yeah.
area of concern.
At the end of the day, they ended up dismissing the chief. They dismissed it. They claimed he was on probation. They put him on probation at one point, according to the complaint, and then towards the tail end of that probation, basically just they terminate him for insubordination. I believe, which is kind of, I don't know really where that was, what it was, and then there was also a suggestion within the termination that it was as a result of having some sort of inappropriate sexual relationship. Doesn't really divulge further what it was a subordinate or what it was there really, and I
And he
think that's part
denies
of
it.
the
The
issue.
chief, yeah, the chief denies it. The chief denies any involvement in that. So,
Yeah.
and he's referring to it as defamatory. So there was no count for defamation, which very often in a case like this, you almost expect to see some sort of a claim of defamation. So, but there was no separate count for defamation, but he does allege that it was
Yeah.
defamatory.
As part of that. So, and I think the biggest, at least reading the complaint, as the facts are laid out in the complaint, the biggest issue here is doesn't appear as if there was a hearing of any sort. It doesn't appear as if there was some sort of a due process afforded to the chief, which is problematic. I think
Yeah.
to say, I think that that's a fair statement in any
Well, I
situation
think
like
when they
this.
disciplined him initially and they put him on probation, the stated reason was insubordination, but they never gave him any specifics on what he was insubordinate about. And it
Yeah.
raises the question that, he's filing these concerns, he's raising these concerns, and they're probably telling him knock it off and he keeps it up, and then that's the insubordination. Or they feel like he's at some point he told when the members said that they were being harassed, he said contact the city manager. And I'm wondering if
Oh, I didn't even think if that could
that
be,
that
yeah,
like you instead of letting it lie, you're stirring it up. I don't know, but you would think if you're going to discipline somebody, you need to be specific about not. You can't just say you're insubordinate because insubordinate is a conclusion, and
right.
something pet peeve of mine. We always got to get factual. Like
Yeah.
what was the
What did you
specific?
do? Exactly. What is
Right,
the,
what's
yeah.
the factual basis for it. So I don't know. One of those we'll have to keep an eye on, and we'll see.
All right.
All right, next one, Kansas. Kansas. This one is, I don't know. I thought it was kind of light on allegations. This
Mhm.
is Shawnee Heights Fire District. Um, and compared to maybe it's adequate to constitute sexual harassment. I don't mean to say it doesn't constitute, but compared to some of the ones that we see,
Yeah.
it doesn't contain the typical types of allegations that we see. They're a little bit lighter than what we typically see. But we have a
Yeah.
female firefighter who was hired, I believe, in 2017, and she's alleging that there's a particular battalion chief that was kind of at the same time he was demeaning and not uh, being respective of her, he apparently was coming in close physical contact, and those are kind of opposite.
Yeah.
If somebody's kind of attracted, they're going to make close physical contact, but if they really are not treating you fairly, it's kind of going in opposite directions there.
Yeah.
And
Yeah, that's a
so,
good point. And then typically that the arguments would be you're being excluded from things or you're
right.
not, and as opposed to you have both ways here. Yeah.
And one of the allegations was that he referred to the female firefighter as his firefighter, whereas he didn't refer to male firefighters as his firefighters. So, which I think is, I don't know. Again, I think it's kind of light, but certainly adequate, I think, to get by a motion to dismiss or anything of that nature. And that'll be up to the judge and jury if it's severe or pervasive. And but at some point, she complained, and the harassment, or her perception of harassment, did not end. It actually got worse. And then she ended up being terminated. The the choice of words in the termination notice, though, was kind of concerning, that engaging in gossip and rumors
Yeah.
and so on. Let me see if I can get the exact. I don't know if you can put your finger on it, but
Yeah.
um, oh, here in a termination letter, the fire chief accused her of engaging in rumors and gossip, and writes that plaintiff's termination is based on plaintiff electing to simply pursue a campaign against the battalion chief with other members of the department by sowing seeds of distrust and discord. So again, a lot of conclusory language there.
Without
And
many facts to at least back that up.
yeah, so that's
Yeah.
what we want to really, especially in our discipline arena, we really want to be getting factual and not conclusory. Conclusory, it's fine to draw a conclusion, right? Fine to say somebody is ETOH, somebody's intoxicated. I don't
Yeah.
recommend it, but you can, but if you get factual, they're slurring their speech, bloodshot eyes, unsteady gait,
Yeah.
and those types of things. You get factual, then it leads to the conclusion that the person's
Yeah.
intoxicated, as opposed to just saying they're intoxicated. And same thing here with, last case insubordination and
Yeah.
so on. So
No, you're going to terminate somebody. You need to lay out the specifics of why they're being terminated. And that just is, yeah.
yeah, so we'll see. We'll see. It's just this is the most common way we're being sued these days. Either sexual harassment or gender discrimination is number one, followed by race discrimination. So just another one of those cases. How about the next one, man? This is a good one. This one,
Yeah.
FDNY case.
Yeah, we had two in a row here. This is the first
Yeah.
of two out of FDNY. And this is where a court in New York found that FDNY was not liable for basically dispatching. There was two parts to it: dispatching a BLS ambulance to a call that came in as difficulty breathing. The dispatchers fielded the call and made a determination to send a BLS ambulance as opposed to an ALS ambulance to that particular scene. And then, unfortunately, those EMTs got on scene, discovered a patient who was in need of advanced care. So then turned around and said, "Okay, send us an ALS unit," which could happen. It happens every day in this country, right? And however, there was kind of a decision. Those EMTs were on the hot seat, so to speak, because I think it was a 15-minute or 12-minute ETA for that
Yeah.
ALS ambulance, but they were 5 minutes away from the hospital. So, I mean, I think a lot of us have been in this position before, and it's not it's not a very good position to be in. Do
And
you
you typically get scolded for transporting.
Yeah, exactly.
No.
And you're in that. Do I scoop this person up and use my BLS skills and get them to the hospital as soon as possible? Do I wait the 12 minutes for the ALS truck to show up and then they can kind of intervene with their skills? Unfortunately, at the end of the day, well, I shouldn't say unfortunate because I think their decision was rational, obviously based on the court's decision. But the EMT said, "We'll wait for that ALS unit."
Yep.
They did the best they could for that time frame till the ALS unit got there. ALS unit picked the person up, basically intervened, brought them to the ER, but unfortunately, there was some brain damage as a result of, I'm assuming, lack of oxygenation. And just based upon the mention they bring up the intubation and whatnot, I think that's a fair assumption.
Yeah.
Now, as a result of that, understandably, the family's upset. The family filed a lawsuit, trying to, to see that the department was negligent in those two things. In the dispatcher A saying we're going to send a BLS unit to the difficulty breathing call, and B, those EMTs should have done something different, other than wait for that ALS unit. And at the end of the day, the lower court actually said, "Okay, let's bring this to trial. We'll allow this lawsuit to proceed." The city appealed it, and then kind of that intermediate court in the state of New York turned around and said that we're gonna, that this is dismissed as a matter of law.
Mhm.
And that the department has, some immunities here, and then department with, those EMTs were acting within their licensure, within their policies and procedures of the department, et cetera, and therefore were available to, to kind of use those defenses, that immunity.
Yeah, when I came across this case, I was thinking I was going to be discussing this with Brad, and I was really going to kind of talk about what the F is wrong with the New York court system. I mean, why do they go through this convoluted I don't know if you read the case, if you just read my blog about it, but the case is torturous. It's absolutely torturous in terms of the reasoning, the legal
Yeah.
reasoning. And I think most courts would basically say, look, they're involved in a governmental function
Yep.
and they're emergency responders and they're going to be immunized unless it's more than negligence. Now, here in Rhode Island, we do it through statute. There's
Yeah.
statutory immunity for EMS. Other states do it through other ways, but New York goes through this convoluted. I mean, like
I
I
had to
got,
reread it several times, and I
oh
still
my
was having a
God,
hard
it's
time
like
following the ball. Yeah.
why are you making this so complicated? It
Yeah.
doesn't need to be this complicated. But that's New York. And I think, one of the things I noticed when I was writing my first book, I noticed that I'd read, it might be an article or it might be a book. There's several books out there on fire law. And it seemed like they came from a state like New York. The author came from a state like New York, and they were assuming that every state analyzed negligence and special duty and public duty doctrine,
Yeah.
that they all analyze it the same way, and they don't.
No.
And here in Rhode Island, this would be a relatively simple case. It really would. It'd come out the same way, but it'd be relatively simple. Instead, these folks are going through all these intellectual, gymnastics trying to reach the right conclusion. And it's unfortunate, I think, but
Yeah.
you know,
Yeah. But I think at the end of the day, you're correct. The everybody there was doing the best that they could, right? Every step of the way. Everybody there was not a situation if those basic EMTs arrived and said, "Oh no, you need ALS," and turned around and left. That's an issue, right? I mean, that wasn't the case at all here. Everybody, it was just, it was just an unfortunate circumstance.
yeah, it is. And it's not what we do is not perfect,
No.
and they didn't even get to the merits of it because, trying to connect those two decisions, trying to connect through causation, which would have been an issue at trial,
Mhm.
trying to connect the
Yeah.
dispatcher delay to the actual injury, or trying to connect the EMT's decision to the actual injury, I think there would have probably been a pretty significant causation issue.
Yeah.
But at any rate, it is what it is. So, all right, we got another one from FDNY. Yeah, this one.
We
Now,
got the
Bill,
New
I'm
York
not sure
after
if you're
this.
aware. We got Brad is very familiar with this.
Oh,
Um,
okay.
YouTube has first of all, they have these bots that will look
We
over
can't
every
we
word
can't
that
say
we
the
say.
word, right?
We
We
can't
cannot
say
say
the
the
C word. We cannot say
okay.
the C word. If we say the
That's
C
right.
word, we're going to be in trouble. So we're just gonna, uh,
Yes.
I don't know, pick a, Palomino. Say
Okay.
Palomino, right? Whatever you want to call it. But we
Yeah.
cannot. And I screwed up on one recently, and I said the word, and we didn't get dinged on it. But I think it's
No.
terrible. First of all, that YouTube does that.
Yeah.
But they just feel like there's so much fake information out there that even when we speak
Yeah.
truthfully, it creates a
It
problem.
creates an
So
issue.
yeah.
So
But let's see if we can do it without mentioning that
well, this
objectionable
this
word.
this case involves a disabled firefighter from
Yeah,
FDNY
yeah,
that had a reaction to the Palomino vaccine.
yeah,
That allegedly had a reaction to that. However, it's a little bit unique in that he had the reaction to the initial
yeah.
vaccination. And then a period of time went by, and then they mandated. Obviously, well, to start off, FDNY mandated that everybody
That's
get
right.
that.
So he got the first shot because he's mandated, but
Exactly.
he had an anaphylactic reaction.
Reaction to it. Absolutely. And then according to the complaint, was mandated for the second round as
Yeah.
well.
And
Um,
the CDC, apparently he's got documentation that the CDC
yeah,
recommends that if you had that anaphylactic response, you not get the second
the
one.
second.
Yeah.
So, and
So
that's yes. And so this firefighter ended up filing for an accidental disability because as a result of and the procedural history here is that accidental disability was denied. And this is the state agency or the city agency, whoever it is that controls that disability board, found
Yeah.
that
It's the city
the
pension.
city, yeah, that the reaction didn't meet the definition of accident within their regulations as far as, how you qualify for an accidental disability. So as a result, typically you would think you would appeal that. That appeal would be done through administrative hearings. As far there's going to be an appeal process for that.
Yeah.
Instead of that, here the firefighter went to federal court saying that
No,
the
no,
city
no, it's a
violated.
state. No, it's a state.
Oh, I'm
It's an Article 78. New York has this weird thing. It's called Article 78 action. We don't have it in Rhode Island, but you can, any sort of administrative decision that you're not happy with, you can take it through, you can take it to one of their county Supreme Courts, citing this Article 78
okay.
and pursue it that way. So he's alleging, I don't believe this is a federal court unless I'm
I
having
think it
a
was the complaint looks like it is, but you're absolutely correct with that.
oh, you're right. Yeah, so he did. Yeah, so he did.
He must
That's
have
right.
done both.
That's right. That no, my mistake. He did both. He filed an Article 78 action. So that is how you challenge an administrative issue in New York.
Okay.
You're a firefighter, and I've seen Article 78s on somebody getting demoted, somebody
Yeah.
not getting promoted, and all those. So it's how you challenge an administrative decision. And
Okay.
the court upheld the pension board and said that it's not an accident.
Okay.
Okay. So I want to stop there because we went through this in Providence. And when you think about the word accident, one definition of the word accident, or one sort of approach to the word accident, is that it's the opposite of intentional. So that if you get hurt, it was an accident. Like you went to a
Yeah.
fire, you hurt your back. You didn't do it on purpose. It was an accident. It was
Sure.
accidental. Okay. The other definition of accident is like a car accident where boom, something happens and you get hurt. So if you go to a fire and let's say a ceiling comes down on you, somebody's pulling the ceiling, comes down, takes off your helmet, hurts your neck and all that. That's an accident in both senses because it wasn't intentional
Mhm.
and it happened all at once. And they did this in Providence, the city actually, because they were worried about too many disability pensions and all this. So they challenged it and they said the proper definition of an accident is a single thing that happens to somebody. That's the only way you can get an accidental disability pension is it has to be like a car crash. It has to be
Mhm.
like one thing. Okay.
Yep.
What happens if you hurt your back at 5 or 6 fires and you end up with chronic in the broader definition of accident, that's all included
Yeah.
and exposure to toxic fumes. That's not an
Absolutely.
accident. I mean, it's an accident on one sense, but it's cumulative.
Cumulative.
Okay.
Absolutely.
Heart attacks, stress, hypertension, PTSD, all of
Mental
these
health.
things.
That was my head was going right to mental health. Like that's
Right.
very
You know,
often
right. And
culmination.
all of these things. So, and what it looks like to me is that through their pension board case law and other
Mhm.
case law, they've reached the conclusion that an accident has to be like that singular thing as opposed to cumulative types of things. Okay. Or things that are just, like, this
Yeah.
anaphylactic reaction as opposed to the building falling or
Sure.
ceiling collapsing or something of that nature.
So at the end, that's this lawsuit is obviously pending now in federal court. Now that thank you
Right.
for that, and I missed that with the Article 78 action. But now that that state side has kind of been satisfied,
Mhm.
the disabled firefighter moves to the federal side to argue that due process rights were denied, and under New York City city and state law
Yeah.
for
And I,
for
I
that.
think he's going under a couple of different things, both the New
Yeah.
York City human rights law, which I think he's alleging disability discrimination or some form of discrimination, and
Yeah.
on the constitutional side, he's alleging I think a substantive due process claim that this is just not, and I guess I can see fundamental principles of personal liberty and constitutional protection, but he's alleged this is fundamentally unfair and it's arbitrary. that application of the word accident is arbitrary here. Where, if he had gone on a run and got a needle stick or something of that nature, that would be covered. But because he got a needle here as part of a medical
Yeah, required.
job
Yeah.
required, it's not, so it borders on, I think, arbitrary. At least that's what I'd be arguing if I was his attorney.
Yeah.
So, but
No, it's interesting. I've this the first that I've read a case like this. There's certainly plenty of cases out there on
there's many
the
Palomino
whole, yeah,
cases,
many
many, many,
Palomino
many,
cases out
many.
there.
I'm up over 200 in my database right now. So there's then,
Yes.
and some of the, they're alleging religious discrimination.
Sure.
They're alleging First Amendment, ADA, state
Yeah.
disability law, state claims, breach of contract,
Yeah.
you name it. Um, it's being alleged. And I think the ones that there was a case, I believe, out of Washington State that alleged that the fire department was being arbitrary in terms of its requiring its firefighters to get this vaccine because they were allowing mutual aid companies to come in who didn't
Didn't have
have it and say, well, when you think about it,
it.
if it's so damn important
Yeah.
that you can't even employ us, then why, if it is that significant,
It's a good point.
you're gonna fire me, then why
Yeah.
are you letting people come in on mutual aid without it?
Yeah.
Is
Yeah. It's a very good
either it's
point.
that important or not, So
Yeah.
interesting theory. And one court bought it, and then that was maybe about a year and a half ago. One court agreed, and since then we've seen a number of lawsuits
Yeah.
alleging the same thing, copycat.
Yeah.
Like that's what we do. Somebody gets a great idea, and we kind of pile on.
Yeah.
But this is a new one. This is a
Yeah.
new theory here. So
New twist.
yeah,
Absolutely.
it's an unusual
Yeah.
circumstance. So yeah,
All right. I
what do
think
we
the
got?
last one also
Last,
comes out of New York, upstate though. Well, I guess
yeah,
that's, I
this
don't know if
one.
that's upstate. I don't know if Troy is upstate. I know
Well,
Montauk Falls is
I
rather
think there's,
upstate.
I think there's, my understanding of New York is there's New York City, and
Yes.
then everything north of that is upstate.
Is upstate. Okay.
So, and there's nothing south of New York City. So, but
No.
yeah, that's another one where I was hoping Brad was going to, because Brad is an
Yeah.
instructor at the fire academy, and he actually teaches this. So I was hoping he might be able to give us some insight into this. But go ahead,
No.
Bill.
Well, this is basically it's a professional firefighter or a union president for Troy, New York Fire Department was required to participate in a training exercise related to mask confidence. And my assumption is it probably was an obstacle course with your mask blacked out and that
I think
sort
there
of
was an
thing.
entanglement. I
In a
think there's
prop.
I
Yeah.
think it's a series of things over a couple of days, but one of the things is either a maze
Yeah.
and or some sort of an entanglement prop.
Yeah, where I guess it was a requirement of the organization for him to undergo this, and he refused. And as a result of refusing, and there's a reason behind the refusal, and we'll kind of discuss that in a second. But as a result of that, he was disciplined. And here he's arguing that the assumption is that it's they're filing a unfair labor practice charge or they're filing a claim or ULP in the state system with the Public Employment Relations Board that this discipline is impermissible under the state of New York's the Firefighter Bill of Rights that they have there. And the reason behind, for those that are not familiar with the mask confidence training curriculum up at the fire academy, there was a death in 2021. Is that correct?
Yeah.
Or I think it was.
Peyton Morse. Yeah.
Yeah,
And
as an
is that
unfortunate.
just a side note, is this where you went for your officer
Yeah.
training? You went
Yeah.
to Montauk
Yep.
Falls? Okay.
Absolutely. I've been up there. I guess I've been there about 5 or 6 weeks for those classes over the course of like 4 or 5 different occasions. Um,
Hmm.
Basically in 2021 there's a tragic death of a recruit, and unfortunately there was I think some mistakes made there that day, and there was some lawsuits that came up as a result of that, and understandably here I guess the Eric Wisher, who is the president of Troy Uniform Firefighters Association. As a result, he refused to participate in the training, citing that he was concerned for his safety. He was concerned that I guess the processes were not, that were not in place, or he had concerns about the way that the program was operated or run. And as a result, he was going to refuse to undertake the training, and the department disciplined him over it.
Yeah, so you see, someone in his situation, in President Wisher's situation, has a number of different options here. One of which could have been, I believe, he probably could have filed that Article 78 type of an
Mhm.
action, okay, on the discipline. So that would have been option number one. Option number two is to grieve it through the collective bargaining
Mhm.
agreement. I'm not sure if they have civil service. If they have civil service, that would, be another option. And then what it looks like the union did, at least from the news coverage of it, and I don't have any of the original documentation on it, but the union filed an unfair labor practice because what they're alleging is that the training was never negotiated with the union.
Mhm.
It's not in the collective bargaining agreement. And I'm assuming now, because I
Yeah.
haven't seen the actual unfair labor practice complaint. But just for those of you who aren't familiar with labor law, any changes in terms and conditions of employment would need to be negotiated. So if your department has nothing in the collective bargaining about training, and now you want to start mandating training at the state fire academy or whatever, it's going to be negotiated. It's a change in work conditions. So
Yeah.
now, if this is something they've been doing right along, or there's a provision for that, then that's a little bit different as well. But it looks like they're going to be going under that. So really, there's several different options that somebody in Wisher's place could pursue, and he's pursuing, I
Yeah.
believe, was it a grievance and the unfair labor practice, or
Yeah.
the union is pursuing the unfair labor practice.
Yeah. Because I would think the grievance would be the remedy. And my immediate thought was to be because I mean, obviously I'm not familiar with the Article 78 and that
Yeah.
whole process in the state level.
Yeah.
I would think the immediate remedy here would be a grievance of the contract that,
Yeah. Well, that's
is,
in Rhode Island. That's pretty much our only
yeah.
option. In Massachusetts, I went to law school in Massachusetts, so they kind of drilled this into our head in the labor law section anyway, that you have a choice. You can
Mhm.
you can either file a civil service complaint with the Massachusetts Civil Service Commission, or you can grieve it.
Yeah.
And we actually spent some time strategizing on when would you go with one versus
Sure.
the other. Who's more likely to go along with this particular type of an argument versus who's going to be more sympathetic, who's going to be faster, and so on. But
Sure.
you can't do both.
Yeah.
There's going to be res judicata and collateral estoppel applicable, so you've got to pick one or the other. But
Yeah. But no, I'm sure you're right. There's some reason why they, chose that route
yeah, yeah.
strategically, I'm sure.
Yep. So, but interesting. And maybe next week, Brad comes back, maybe we can kind of pick his brain on this particular one. Maybe it'll be resolved by then too. Who knows? Who knows what's going to happen? So, but I can see both sides of this. If I'm the chief and I feel strongly that I've got to get my folks through this type of training
Sure.
so that they're capable, I'd want them to get through it. At the same time, you've got to respect the legitimate concerns of the
Yeah.
union in terms of how you're gonna unroll that. So
Absolutely.
yeah. So all
Absolutely.
right,
And
man.
I believe in it. I think it was that exact, it was the fatality occurred during that type of exercise back in
It did.
2021. So
Yeah.
it's
No,
very closely
he was
related.
he was a
Yeah.
young fire, as I believe
Yep.
he was a recruit,
Yes.
and part of his recruit training.
Yeah.
Whereas Wisher is, he's been around for a while.
Sure.
But yeah, there's still some litigation out there pending, I believe, on this. So some of it's been resolved, I think, but
Yeah.
it was kind of a heart-wrenching thing for everybody to go through. So,
Absolutely.
all right, man. Well, I think that's going to do it for another edition of Fire Law Roundup. You wanna add in anything? What's hot in the FLSA? What do we?
No, Well, we got a couple of actually we got a couple of recent regular rate lawsuits. There's a new regular rate lawsuit just got just filed last week. A kind of an interesting twist. I really don't have the time to get into it now, but on the inclusion of whether or not, money paid to employees for benefits typically is excludable from the regular rate. And there's an exception on that. And there's a case out of San Diego County where the employees are saying that policy, that insurance policy was transferable. And as a result of being transferable, doesn't meet the exception.
Oh,
So I'll be blogging on that. So if you're firefighterovertime.org,
okay.
you will have a little more information on that by Wednesday. I'm untangling it as we speak. But yeah, it's an interesting, the first that I've seen of this, the first time I've seen a lawsuit involving that. It's typically money that's paid to people in lieu of benefits that has to be included in the regular rate. That's the typical, that we've been talking about for, probably about, 6, 7 years now,
Yeah.
regularly that needs to
I
be
just
included.
was working on an article for Firehouse on that very issue. It had to do with meal reimbursements on
Oh,
deployment. Okay, so
okay. All
yeah,
right.
so similar issue, but the payment to a third party, but then if it's transferable back to the
Transferable.
person.
It's or to a third party, the fourth party, I guess it would be. It's a unique twist because
Oh,
it was a yeah, it's a transferable insurance policy.
uh-huh.
Yes. So
Okay. Yeah.
I'm
Well,
unpacking it as we speak.
yeah.
That was this afternoon was I
Well,
was
I
digging
was
through
out in
those
Las Vegas.
regulations.
I was out in Las Vegas last week, and I got quite a few questions on the FLSA. A lot of questions. Particular battalion chiefs. That seems to be where, on the executive exemption,
Yeah.
that seems to be where most of the consternation is coming from. Whether or not, pretty much clear. Company officers are hourly. That
Yeah.
much is pretty clear. But excuse me, the line chiefs and whether or not they are or not. So
Yeah.
yeah.
No, that continues to be a hot button topic for
Yeah.
sure.
So. All right. Well, that's going to do it for
All
another
right.
edition of Fire Law Roundup. We'll see everyone next week. Bill, thank you. Thank you
Thank
for
you for having
pinch
me.
hitting. Good job.